Please join me in welcoming Matthew Hammer from Cassels.
Hi, everyone. Thanks to AJ for that great presentation. Thanks to all the organizers for putting this together. And it's been a very informative day for me so far, for sure. While I wait for slides to come up, I'll just say thank you again, AJ, for doing the land acknowledgement. I think it's very important. I'm not going to... we can change up the order. Do you want to go?
What the DJ says.
Okay. But yeah, and the FPIC content, Indigenous ownership that AJ talked about, very important. I'm going to shift gears a little bit. I think something not quite... It's lunch. I'm definitely not going to be as interesting as lunch. But I'm going to talk a little bit about some reflections on CDR and DAC deployment in Alberta, the development of regulatory regimes. And I think it's on a similar topic ultimately in terms of what Catherine Hayhoe was just talking about how we work together to get to our goals. I'll touch on a whole bunch of different topics. The standard disclaimer, nothing that I say today is legal advice. I'm going to talk on a kind of a potpourri of topics. 3 pinch points I think we see in regulatory frameworks in terms of the development of CDR and DAC in Alberta. And I was validated a little bit this afternoon on the end of the DAC panel when they were talking about some of the things that are key to moving projects at scale forward, being certainty of funding and access to renewable generation. And I think both those are areas where regulatory frameworks continue to evolve and arguably more development is necessary. So, funding. Tax credits and grants. Point of the slide is not to talk about the details of what's available, but to point out that governments are investing in making these industries more competitive. The carbon capture utilization and storage investment tax credit available at the federal level provides a higher rate for direct air capture and a lower rate for other forms of capture, lower rates again for the other elements of the carbon removal chain. Importantly, the tax credit is not available for pilot projects. So you have to be moving ahead with a full-scale project. And carbon must be stored in eligible uses, which excludes generally enhanced oil recovery. And I think that the time is also key to look at here. We were talking about the timelines of development earlier today. The theoretical phase out of this credit is 2031 to 2040. So there's an expectation at the federal government that that this industry will develop over time. At the provincial level, to complement this, the federal tax credit, there's an additional 12% grant for capital costs, and the provincial government, again showing different policy focus, focuses that capture on hard-to-abate industries, including oil and gas, heavy industry, and so it's a much more targeted credit and a targeted focus. The other major area where governments are investing in supporting the financial side of these projects, as opposed to one-offs, which is also important, is compliance carbon credits, which we also talked about a little bit already today. So at a high level, in Canada, we have a federal backstop for industrial carbon emissions, no longer a federal backstop for consumer carbon pricing, but a federal backstop for industrial carbon pricing. And in Alberta, that's implemented through the Technology, Innovation, and Emissions Reduction Regulation. But the fact that there is no federal market and no federal unified industrial strategy makes it more difficult to implement a unified and cohesive approach to incorporating carbon removal in the compliance market. In Alberta, there is a protocol, has been for some time in terms of the development of carbon capture and sequestration projects. It can be used for DAC or capture at large facilities, again targeted in terms of the province's policy priorities. And recently there have been changes to kind of provide greater value for sequestration credits. A little too technical to go into here, but the changes allow facilities to offset their emissions directly rather than using credits for compliance, which allows them to kind of get greater efficiency on the use of those credits. All of which is just to support the use of capture credits more deeply in the Alberta emissions reduction scheme. At the federal level, we see the same kinds of developments, with a draft federal offset protocol for direct air carbon capture and geological storage. It has many interesting elements, one of which is a strict requirement for renewable energy additionality. Some of the commentary we were talking about already today around geographic location and temporal matching still being developed. And so at provincial levels and at federal levels, we see a desire to incorporate carbon removal into these compliance mechanisms to expand the options for funding for long-term offtake beyond the voluntary market. The sustainability of these initiatives depends, of course, on the underlying price set in the federal system, which is a matter of some debate at the moment. The federal price is set to increase. But the provincial government in Alberta has said that they will not be increasing the tier price at the same rate. We know that the Supreme Court of Canada has said that the federal government has the ability to set a national backstop, whether there's political will to maintain that national backstop, as many of the political developments that have been discussed today kind of progress globally and in Canada, remains to be seen. And that level of uncertainty, as we know, increases the cost of capital and makes it more difficult to fund these projects. Renewable generation. Access to cheap electricity is very important, and it's cheap renewable electricity, and it's been one of the drivers for the development of the DAC and CDR industry in Alberta, because we have historically had a high availability of cheap renewable energy, and that cheap renewable energy has been procurable through corporate power purchase agreements, which are not available in many Canadian markets. The Deep Sky purchase from Lethbridge 1 is just one example of those kinds of arrangements, and corporate power purchase arrangements for carbon removal require greater attention to a range of different issues, many of which we've already discussed in terms of temporal resolution, spatial resolution, delay damages, availability guarantees, and additionality. Basically all coming down to the need for renewable energy precisely when and where it is required and to be truly additional and generating, matching the energy requirements of the facility. So power purchase agreements are one form and have to date been the main form of generating renewable energy for these projects. The other form is on-site generation. And on-site generation is a hot topic in a lot of areas these days. A lot of new technologies, including data centers, are interested in procuring energy on-site. From a carbon removal perspective, on-site renewable generation can mean meeting all those matters under the PPA framework through direct siting, rather than through contractual arrangements. On-site generation, however, doesn't fit neatly into existing regulatory frameworks. And no one wants to hear me drone on about rate regulation and the nature of utilities regulation, but the bottom line is that these kinds of arrangements are often viewed with skepticism by existing regulators. and require particular attention in terms of siting, corporate structuring, all these kinds of things that lawyers love to talk about and no one else does. There was a recent decision outside of the carbon removal context dealing with these issues. McCain Foods wanted to build a renewables facility that would power its expansion, partnered with a developer to do so. The developer would own the project. The AUC said that that arrangement wasn't permissible. The renewables facility was all going to be located on land owned by McCain, but it was land spread over several parcels, across a highway, across a railway. And the AUC said that arrangement didn't fit with the current regulatory framework. This is the kind of thing that hampers innovation, as we were talking about earlier today as well, and makes it more difficult to move these projects forward. Do I have time? 5 minutes, okay, perfect. Sequestration, last area of development. This is an area where we've been working on these developments in Alberta for a decade. Was optimistic there, more than a decade, about 15 years. But an area where the law continues to evolve, and an area that continues to be high conflict as we figure out how to deal with, I know David's going to talk about land uses, competing land uses, but in this case also competing subsurface interests. The basics of the framework for sequestration in Alberta have been in place since 2010, 2011. When the Crown declared that it owned all the pore space and gave itself the ability to issue tenure by Energy and Minerals, and gave the responsibility for disposal to the Alberta Energy Regulator, a regulator that is well-versed in dealing with subsurface matters and disposal schemes historically. The Shell's Quest project, approved in 2012, utilized these regimes to get a successful approval, an approval that dealt with many of the same issues that we are now dealing with in the Enhance proceeding mentioned at the bottom of the screen, which we'll get to in a moment. Issues around subsurface use, issues around potential for induced seismicity, among a range of other things. Fast forward to 2021, 2022, carbon storage hubs. The government issued pore space in a competitive process, a total of 25 hubs, and a process for small scale and remote sequestration outside of those hubs as well. So there's a lot of activity in the area, a lot of things moving forward, and a lot of this regulatory framework still being built, developed, and fine-tuned as we move forward. The latest way to see that fine-tuning in action is Enhance Energy's Origins project, currently in an AAR proceeding. There were dozens of statements of concern, which are interveners stating that they want to object to the project or have concerns with the project proceeding. In that proceeding, brine-hosted minerals were among several issues raised in terms of the question being, what are the effects of injection in the area? How does that affect existing mineral rights holders who have the right to remove minerals? And from a technical perspective, can you still extract those minerals? Whose rights come up on top? And these are issues that the AAR is used to dealing with, the Alberta Energy Regulator is used to dealing with, but this is a new context and a context where the questions are still unanswered. This is a very technical proceeding where there are hundreds of pages of supplemental information request responses, which is where the regulator asks for more information on issues like, again, induced seismicity, like these mineral rights issues, like technical issues related to certainty of storage. The point in all this is that this regime continues to evolve, like many of these regimes do, but we have the tools in Alberta to address these problems. And there are ways to work together to build the kind of CDR industry and DAC industry that is fit for the climate moment that Catherine Hayhoe was talking about earlier today. I'll stop there. Happy to talk about lots of different things and questions. Thanks all very much.